Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today we're going to be talking about questions regarding bankruptcy, Chapter 7 and Chapter 13 under the Bankruptcy Code. Joining me as always, my co-host Jesse Barrientes. Jesse, how are you, sir?
I'm doing great, Dave. How about yourself?
I'm doing well.
You're looking pretty good, pretty svelte.
Yeah, I'm doing all right.
Good for you.
I'm doing okay, trying to stay in some shape here.
Excellent.
Let's jump right in.
Okay, so hey, there's a lot of, especially now, we're in the season, Dave. Okay,
We are in the
We're in the
spending
season. We're in the season. So what's going to happen? Everybody's going to have impulsive, subconscious, perceived impulses. Okay, and they're going to wake up in January with a big credit card bill or maxed out credit cards or all kinds of things.
And why is this happening?
Well, it's
Black Friday,
right. Cyber Monday.
Mm-hmm. Charitable Tuesday.
Well, it's so easy for people to spend with money that you don't have.
Why not resist this though? Why not resist it? It's all over the radio. It's all over the TV. It's all over the internet.
Everyone wants a deal.
Is that what it is?
Yeah. I mean, did you get anything for Black Friday?
No.
Or Cyber Monday?
No. But I'm an outlier. I know I'm different than the norm.
I didn't either. There's no sense in. I mean, I don't know. There was nothing I really wanted to kind of take care of. So I did look, though. There are a lot of
people that are addicted to this. They fall
are.
for it.
They're
involved in it.
That's a good way to say it, addicted, because it's so easy now to sit in front of your computer. And now you could they make it so easy, you could set, this thing is coming up in an hour, so you could set little reminders and have it pop up and everything, and it makes it kind of more thrilling, I suppose.
Right, and people pay a company a certain amount per year just to get something the next day. Like, what do you really need the next day that you couldn't wait a few days
but I'll tell you, shipping is, you could buy things, and the shipping costs almost as much as what you're buying, so, if people use that a lot for other stuff, that's it. So let's hop right in. So we're in the season, and so what's going to happen is there's going to be that crunch, and you're probably going to be busy in January, that's for sure.
I'm going to help a lot of people, hopefully, who overspent and didn't have the means and fell into some other problems. You're talking about spending on the credit cards is what you're talking about.
Right, on the credit cards, and that's, well, again, when you spend, it's different to use your credit card and then pay it off, okay, as opposed to spend money that you don't have.
Right.
And
there are people that spend too much on themselves, and there are other people that do it out of good nature, and they provide for their family and their nieces and nephews and things like that, just to try and make their holiday better.
Or people
doesn't always work.
No, people want to keep up with the Joneses sometimes, and or like you mentioned earlier, I think that's more prevalent. Is that people are they're an addict. They don't go with money. And here's the thing: if you can't take care of a little bit, certainly a lot. If these people, if you gave them $1 million, boy, that would be gone. Okay. So anyway, let's get down to brass tacks. We can talk about some stuff we have with relief from that. What is a Chapter 7?
Well, the Chapter 7 is basically the fresh start. That's where someone who doesn't have a lot in the way of assets but has a lot of debt can apply for a Chapter 7 and eliminate credit cards, personal loans, past due utilities, auto repossessions, things like that. And they can still keep whatever property they have because it usually falls under a certain limit of property that they're allowed to keep when they go through this process.
So there's a time when someone would certainly want to file. Well, when would you want to file? When would somebody want to file Chapter 7? I mean, if I have a couple $1,000s in debt, or
it's
$5,000 or $6,000. I mean, what generally do you look at?
I usually tell folks if you can bail out and come out from the hurdle that you have within 6 months on your own, then it's not worth it to file. Just toughen it up, budget a little bit, take care of it, and save your credit rating and preserve a bankruptcy for when you really need it, if at all. However, if you're someone who will not be able to come out clean after 6 months and you're just going to be struggling in the same cycle of getting nowhere, just paying interest, and it doesn't look like a bright future for you,
right.
Then Chapter 7, the fresh start, wipe the slate clean, get a new beginning, and then be able to start contributing towards your family and other businesses again once you've gotten that fresh start. Well, otherwise you're trapped.
What if, okay, sure, I don't think I can necessarily make it here, but you know what? If I were to take some money from my retirement, I could pay off those few credit cards.
Well, that actually would be a huge mistake because the money in your retirement, as long as it's qualified for retirement purposes, is protected. So you could have hundreds of thousands of dollars in your retirement account and still eliminate miscellaneous debt while going through a bankruptcy fresh start. So you don't want to necessarily take protected property and utilize it to pay debt. It's a big mistake that people make because they don't seek professional advice before they start doing some of these maneuvers and transferring and getting property out of their name and signing the title of their car over to their brother and things like that that are just
to try
silly.
that, which is clearly fraud.
Absolutely.
Right. So, well, let me ask this. We've talked about on other shows, and also now there's a push for people to have access to justice, and for people to really they've got state forms of all kinds and in all different kinds of disciplines and areas of the law and everything else. And so, hey, you know what? Why can't I do it? Why can't I do it myself? I mean, are there any?
You could actually, but I don't recommend it.
Are there any pre-filing requirements? Do I,
Yeah, there are several, and I'll get to those in just a second.
Sure.
But I wanted to make a point that the bankruptcy forms were changed many years back in an effort to make them more readable and usable for someone filing on their own. But at the same time they made the forms easier, the whole process got more difficult. So it really defeated the purpose of creating new forms geared to a pro se filer when there's all these other requirements that are going to knock a pro se filer kind of out of the box. And those are the credit counseling that has to be done before a case is officially filed, providing pay advices, proof of income, taxes, and then, of course, preparing the petition, which is a list of all your assets, all your liabilities, your income, your expenses.
Ooh, that sounds like a tall order.
It is a tall order, and if you don't have special software to help you do that, you're going to be sitting at a typewriter or on your computer filling out forms through some other company that really doesn't understand what Illinois law is and how the trustees and the judges want to see documents prepared in this area.
You know, it's funny, just like on a side note, okay, because we've been practicing for a long time here. And so I can remember back in the day, Dave, actually typing, that's before the forms changed, typing the bankruptcy forms on,
That's right.
Actual typewriter. Okay, for the folks at home, if there's any kids watching, a typewriter is a machine that types letters. Okay, similar to a computer, right? But yeah, the good old days.
It had carbons because it was in multiple copies.
Yeah. Those were the days. So, well, talk about a little bit about some of those pre-filing requirements. So, okay, so all right, can navigate possibly through those forms and everything else. So you mentioned there's a credit counseling class that you have to take.
Yeah, there's actually a pre-filing credit counseling. There's something you have to do after the case is filed, but before it's filed, you must submit to a credit counseling session.
And what's that?
Well, you could do it online, you could do it over the telephone. Sure. It takes anywhere from an hour to an hour and a half.
And what does it cost?
Typically about $15 to $25, depending on the provider.
Too bad.
Right. It's an exercise. It's putting the debtor or individual through a process where they have to listen to information, provide information about their budget, and it's a prerequisite to being able to file a bankruptcy.
So what happens if I file my bankruptcy and then I took that class?
Your bankruptcy is technically void, as if you never filed.
Well, how's the judge going to know, or the trustee going to know?
Well, the certificate of credit counseling has to be filed with the court. So if it's not filed at that time, if it's not attached, you're going to get a deficiency, and then you're going to get a motion to dismiss. If you actually file it and it was after the case is filed, the court on their own motion is going to bring a motion to dismiss that case as being void from the beginning.
And so ab initio, from the beginning.
Yes.
So that just means that I just learned a very expensive lesson.
Yeah, you just blew your filing fee.
And what is it these days to file a
Chapter 7 is $335 to the clerk of the court. That's anyone who files a Chapter 7 in the U.S. has to pay $335 for the privilege of getting out of debt, unless if you're a pro se filer filing on your own with the inability to pay, you could apply for a fee waiver. But again, you're doing all that on your own. You're acting as your own attorney, and I don't recommend that.
So let's talk about so it's just like anything else. It'd be like me trying to rewire the house, okay? Because I'm not an electrician. Very clearly.
You can watch some YouTube videos and take your chances with that
You
juice.
can.
I wouldn't do it.
I wouldn't do that either. Changing a light bulb, cool, but I don't know about rewiring the house. So,
Some people feel they're already broke. They don't have the ability to pay for counsel. They'll just do it on their own. When really, that is kind of the wrong way to go. There are some people who can do it. If you want to spend a lot of time and navigate the system and fill out the forms and follow the requirements, you can do it. But it's very treacherous these days.
Very treacherous. Okay, so it's important to find somebody who knows what they're doing, somebody who's done bankruptcy and who's familiar with the law and who's familiar with the procedure and everything else. So, all right, so, boy, we get a lot of robocalls. A lot of people just get robocalls. Forget about from creditors, just calls in general. So a lot of complaints that I hear from clients are, hey, look, man, these people, and they're not even doing it right. They're calling me at all different kinds of hours, even though I told them to leave me the heck alone, and they're very rude with me. They call me at work. I'm worried that I'm going to get in trouble at work because they're calling for me at work.
Yeah, they're violating the Fair Debt Collection Practices Act, which is a violation, but again, until you slap
How do
them
I
and
stop them?
enforce
How do I stop them from calling?
You'd have to file a suit.
No, but I mean,
Oh, well, if you actually hire an attorney for a bankruptcy,
Sure.
you can then refer those creditors to the attorney. And by law, under that act I was mentioning, they have to call the attorney to verify whether that person is a client and make any offers or any communications directly through the attorney. So you get that break the minute you hire counsel. You've got a number, you've got a hotline you can refer these creditors to and stop the harassment.
But when you file, is there anything in procedure?
Yeah, the actual filing will trigger a case number and a notice that goes out from the clerk of the U.S. Bankruptcy Court about 5 to 7 days after the case is filed.
So it's an automatic stay?
Yeah, it's an automatic stay, which is an automatic stop sign, let's say, that goes out telling creditors that they cannot take certain actions. There are some creditors who are not stayed or not stopped, and that would be child support, criminal matters,
I was going to ask you
police
about
matters.
So let's talk about. Now that you mentioned that, let's just talk briefly about what debts are not eliminated. You mentioned a handful of those.
Well, student loans,
right?
recent taxes, recent parking tickets in the city of Chicago, parking tickets in general outside of the city of Chicago, child support, maintenance, debts incurred via fraud, traffic fines, DUI costs. There are a lot of non-dischargeable debts, but there's also a lot that go away.
Well, let me ask you this. What happens if, I had a, car accident and I didn't have insurance?
Okay.
And, they're suing me here and, now they've suspended my license.
I want to know, was it DUI related?
No, I just didn't have insurance. I got into an accident.
Okay. That is something that Chapter 7 bankruptcy can help eliminate. As long as it wasn't DUI related where someone was personally injured, everything else is wiped out. So the property damage, the fact that you didn't have insurance, you'll still have to deal with the traffic court and probably pay a fine for driving with no insurance. But the underlying debt that you hurt someone else's property, that could be wiped out in a bankruptcy and you could preserve your license.
What about, the personal injury? I mean, again, not related to DUI, just an accident. And
Personal injury is wiped out unless it was DUI related. That's the big kicker. If it's DUI, all bets are off on the personal injury side of it.
Right.
And this is a good point you bring up. This is why you want to have insurance to protect yourself from someone who doesn't have insurance. Because you can't rely on the other person who's driving around eating, texting, makeup, phone, doing all this crazy stuff. You can't rely on that person who's swerving lanes to have insurance. You have to make sure you have uninsured motorist coverage to protect yourself.
in an acceptable amount. I believe in Illinois, you only need to have $25,000, which is really nominal.
Yeah. And I'm so tired, Jesse, of this phrase, distracted driving. It's negligent driving. You're not distracted. It's negligence.
Yeah, that's true. You all you have to do is look in the car next to you and see somebody looking at the phone.
Yeah. I hear a lot of horns going off when I'm driving. That's all I can tell you. There's a lot of horns going off, a lot of lanes being changed.
I've trained myself, so I really don't. You have the Bluetooth in the car. Really don't look at texts because I'm driving, doing what you're supposed to do. So let's talk about. A lot of times people are concerned about in Chapter 7 as a fresh start, Dave, it's just tough. I screwed up here because of the holiday, trying to give my family a nice Christmas, and we have a house, and I don't want to lose my house. I mean, I'm not behind on the house. It's just that I own the house. We have some equity in the house, and I've always been told that, hey, if you file a Chapter 7, hey, they're going to take my property to pay the creditors, and then that's it. I need to keep the house.
Yeah, well, first of all, sometimes it's not your fault. You might have spent for the holidays thinking that you were going to be able to maintain your level of income, and then the company decided to lay a certain percentage off around the holidays. So that does happen a lot. So people get caught in the screws there. But in terms of the housing,
right,
you are able to protect a certain amount of equity in real estate. So for one individual, it would be $15,000 worth of equity. If you're a married couple, $30,000 worth of equity. So you can actually get out of debt, keep paying for your house, and keep it free and clear from the long arm of the trustee and the creditors, as long as you don't have significant equity. And you can even have more than 30 because the trustee has to factor in what it would take to sell that property. 6 or 7% for a realtor, closing costs, title expenses. So in actuality, you can have a little bit more than the exemption amount and still be okay. And these are things we analyze before we file for somebody.
All right, so I'm going to know what I'm going to be able to keep and everything else too.
You're going to have a good idea as to whether or not your property is subject to a risk of a trustee wanting to administer that asset. And if so, we can possibly buy out the trustee's interest for $2,000 to $5,000 or something in that range. So you don't have to lose your house.
Okay. Yeah. And still be able to work something out to be able to keep that.
Yeah, it depends on the aggressiveness of the trustee, and the actual value might not be what you thought it was. It might be worth more.
Okay, well, yeah, so. That's it's funny how people undervalue things when it's convenient and overvalue them when it's convenient. We see that a lot in divorce law, where if you're buying my interest out, I want that interest to be, or the equity or the value to be as high as possible, and you want it to be as low as possible. So
yeah. And as a side note with real estate, the value is not what Zillow.com says. Okay, that's an estimate. You want to go to a local realtor and ask them for a fair market evaluation, because if a trustee does want to sell your property, they're going to hire a realtor. They're not going to Zillow.com.
Right.
They're going to hire a realtor. They're going to put it on the market, and it's what someone is willing to pay. That's the true market value, not a website estimate.
Right, but that's a good place to start, to just kind of give you an idea on where things are.
A lot of people don't know what their house is worth. Right. It's amazing to me.
So, some of the other things that the clients tell me is that, hey, I have a few credit cards. I have a couple credit cards that I've had all my life, and there's no balance on it. So I don't want to claim those because there's no balance on it. So
you're up to date on those because you like those cards.
It's
you're running up the other ones.
Well, I haven't used the Macy's, haven't used a couple of the other ones, and so there's no balance on it because I've had them all the time. Yeah, and I was using this other one where I'm getting points. So that's kind of the reason. So I don't. Can I keep those other ones? And
unfortunately, no.
But there's no balance on it.
Right. You don't have to list them as a debt because technically you don't have a balance, like you mentioned. However, the credit card companies specifically are going to subscribe to a service that notifies them of bankruptcy filings, and they're likely going to send you a letter terminating your charging privileges because they want everyone to get a fresh start so no one's playing favorites among the cards. That's why these issuers terminate people even after they've filed with a zero balance.
Well, here's the other question I get a lot too, and that's, okay, well, man, this is going to, am I ever going to get a credit card again? I mean, it's pretty convenient to have one. And so now after I file bankruptcy, boy, I'm not going to be able to get a credit card. I'm not going to be able to buy a car or even a house.
Well, you will get all forms of credit eventually and a credit card pretty soon. Typically 6 months to a year after filing, you'll get some offers. You can also use your debit card, much like a credit card, the convenience of plastic.
Well, that's no fun, Dave. That's my money, not somebody else's.
That's true, but you have to start off slow after the filing. Yep. You could also get a secured card, by the way, where you put money in the bank account and you could charge up to that amount, and that starts reporting positively to the credit bureaus, and it's considered a trade line, so that a vehicle, maybe a small furniture purchase. Those 3 trade lines will work like magic in improving your score after about 6 months to a year.
But as long as I continue to pay my bills on time, right? That's the key, isn't it?
You have to change whatever problem you had before. So if you were an overspender, you have to budget now. If you were someone who couldn't resist the temptation to
Sure.
take these offers, you have to be able to just say, no, I'm on a cash basis right now until I get some money in my pocket.
Well, another question that gets frequently asked is my job going to find out about this? It's kind of embarrassing. Are my neighbors going to know?
Well, typically, no. Your job has no reason to know unless, with one exception, if you're already being garnished for something, then your employer is going to find out because a bankruptcy notice will have to go to them to stop that wage assignment or wage garnishment. So, but if you're not being garnished and you're doing a Chapter 7, there's no reason for your employer to realize it or know unless you tell them.
What if I work for a bank, Dave?
It's no problem. You're able to file bankruptcy. It's federal law. You have the right to file.
Not going to be an issue.
You cannot be discriminated upon based on the fact that you took advantage of existing federal law to get a fresh start. They just can't do that. It's specifically in the code that they cannot discriminate.
What does the process, the timeline look like for Chapter 7? Let's say, hey, I come into your office today and everything is done. I've given you all the documentation you needed. I took the class, the pre-filing class, and I'm just coming in to sign off on the petition that you've drafted now, so you're filing it today.
Okay, if the case is filed today, you're going to get a court date. We call it a court date where you
Okay.
meet the trustee. It's a meeting of creditors.
What happens
technically.
at that meeting?
Well, the trustee is going to swear you in, ask you a series of yes/no questions based on the documents that were filed. Trustee's job is to make sure that everything is complete and accurate and that you don't have any assets that could be taken and sold, non-exempt assets, I should
Right,
say.
that we talked about, like you said, we have certain wild card exemptions that we can apply.
Right, and the trustee will typically make a finding of no assets in a Chapter 7. That meeting's about 4 to 6 weeks after filing,
Okay.
and then the final letter of discharge completing the case comes approximately 2 months thereafter. So you're looking at about 110 days from filing until discharge, with typically only one appearance required 4 to 6 weeks after filing, and it's a 5 or 10 minute meeting. And your attorney will be there with you to guide you.
Okay. Well, that doesn't sound
bad.
so bad. Well, what happens if, because there's a lot of people that are in they make a lot of money, but they haven't made wise choices. And so, for the other people, they're looking at that and saying, wow, if I made if I made the 125 or 150 that you made, I wouldn't be in this situation. How could you possibly be in that situation making that much money? So what happens, though, there's another chapter of bankruptcy, Chapter 13. How is that different than the Chapter 7?
13 is a repayment plan. So you're actually reorganizing your debt and paying back either 100% or as little as 10% or less to a Chapter 13 trustee who, much like a dealer in poker, is going to divvy out a little bit to all your creditors per month pursuant to the plan that you proposed. And the plan will last anywhere from 3 to 5 years. So it really gives you a chance to take a breath, pay according to your budget, whatever you have available, known as your disposable income, and do this over a 3 to 5 year period, and it stops the creditors.
Well, that's going to be tough, isn't it? I mean, I'm going to be on a shoestring for however long that is.
It's not going to be a walk on the beach, but it should be something that you can afford. You just have to be careful and stick within your budget going forward. You can't get extravagant.
Typically, what would you say are some of the reasons that people do a Chapter 13 or consolidation?
Well, someone who fell behind on their mortgage and wants to save their home can put the part that they fell behind, known as the mortgage arrears.
Okay.
They can repay that over 3 to 5 years and make the regular mortgage payment on time once again. So it basically says to the lender, we're going to keep our house, we're going to pay you what we owe you, but we're going to do it over time. That's one example. Another would be someone behind on their car who doesn't want to have a repossession, or it got repossessed and they want to get it back. We could do that under Chapter 13.
But that has to be more timely. Once they take it, who knows what happens to it then?
Well, you got 21 days before they can sell it by law, and usually people want their car back real fast.
Right.
So usually within a couple days, they're taking care of
They're on
business.
the phone taking care of it. So when you file your Chapter 13, so basically you have to pay all of your secured creditors back 100% and your unsecured creditors as little as 10%, all the way and up to 100%, depending upon your available monies left after your allowable expenses are paid.
Yeah, in general, that's correct. There are some exceptions where you can actually pay a secured creditor just the market value of the item. For example, an older vehicle, you can actually pay the market value of the vehicle and then 6% interest, and pay the unsecured portion of the vehicle at a percentage. That's getting a little technical, but for the most part...
Term of art, cram down?
Yes, yeah. It allows you to keep the vehicle and pay for it in a little bit different way than if it was a newer vehicle.
And so in a Chapter 13, is my boss going to know, is my job going to know?
Typically, yes, because for the most part, Chapter 13 trustee payments come through a payroll control order, which comes out of your wages. Now, once again, your payroll, or your job rather, cannot discriminate. You have every right to file a Chapter 13 under federal law and have that money come out of your wages. It's just another deduction, whether it be child support,
taxes,
direct deposit. Yeah,
right?
It's nothing that's difficult for employers to do. They're just putting forward or cutting a separate check to the trustee for a certain amount per pay period. It's very simple to implement, and there's no discrimination.
Is the procedure the same in terms of the pre-filing requirements for Chapter 13?
In terms of credit counseling, yes, that must be completed. The only difference for the most part is instead of 1 year of federal taxes, the debtor has to provide 4.
4 years of tax. What if I didn't file for a couple years?
Well, there has to be a reason why you didn't file. If you
I didn't make enough money.
We would do a statement that says you were not required to file.
Or, there was that 1 year when my ex took the deduction for the kids and she wasn't entitled to them because I was supposed to get them.
Well, something was still filed, correct?
No, I didn't file. It's just, we're trying to work that out in court here, in the divorce court.
Okay. Well, I would recommend you talk to a tax professional in that circumstance. If you were required to file, you can file late. It's just a requirement of the Bankruptcy Code that the most recent 4 years of federal taxes are filed. It doesn't say they have to be filed on time. It doesn't matter if you owe money or not. It's just one of those requirements that has to get done. If you owe taxes, that's part of the Chapter 13, part of the reorganization.
So in a Chapter 13, are they going to take any of my property away?
No. In a Chapter 13, you are 100% protected. You're going to keep all of your property unless you decide in your plan that you want to surrender something. For example, a vehicle that you can't afford, or a timeshare is often surrendered.
Well, then how is that treated?
Treated as an unsecured creditor if you give it back.
Okay, so just like a credit card debt.
Just like a credit card debt, which could be as little as 10% after it's surrendered.
Okay, well, that's certainly something good to know. The timeshare, that's one of the bigger ones that people try to get rid of to take care of that, too.
Yeah, there's a lot of ways to do it. Jesse, we're out of time.
Oh, okay.
Great seeing you.
You as well. Happy holidays, Dave.
You as well.
Thank
Talking
you.
about 7 and 13 under the Bankruptcy Code. We'll see you next time. I'm David Siegel. You've been watching Legal Action. Thank you. Take care.